In continuation to what I was discussing here is what was patentable was filed as a bioinformatic application with the modules and all, and because according to her, the kind of microbes she had worked on is used in bioremediation, and the current softwares were not enough to justify the results. And generally, when we talk about biotech applications, somehow or at some point of time you use PCR. PCR is basically polymerase chain reaction, and it's a costly affair. The cost of doing the experiments at some place, blah blah blah, is a costly affair. Now, after the filing of that main parent application, uh, obviously she talked to a couple of other patent attorneys, and they filed what she said. But those patents are not granted because that is not patentable under the Indian patent law. See, filing a patent application is one part, but it has to certify, and it should not be coming under the ambit of section 3 of the Indian Patent Act. Having said that, after that, the only patent which was granted was the patent which I had drafted for her. And after the grant, she paid the annuity fees few years, and now it is lapse. And I am of the opinion then, in very simple words, when you are filing a case against any XYZ company, you have to make sure that your IP is secured, and blaming an attorney is not the right way of doing things. Attorney will say once. Attorney is not going after the client and say, you file an international application, blah 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 blah. You tell them once, and if they want to do it, they will do in the stipulated time. And if they don't come, the onus is not on the patent attorney. The onus is on the inventor to make sure that everything happens in a timely manner. Interestingly, copyright law is much more wider, and accordingly a copyright application was filed. So under the Bernese Convention, it's applicable in 140 plus countries, and I think this will be a very interesting case laws for any of the books. And I am in the process of writing multiple books. I am in the process of even working with University of Geneva, where one of my chapters is on artificial intelligence and philanthropy. Apart from that, I'm dabbling with multiple books right now because I have so much of data points, and I believe those data points have to be presented in a manner that people are able to appreciate what intellectual property right is all about, rather than blaming the attorney that the attorney didn't do XYZ. That will not suffice the purpose of the client. The client has to understand that. And if the client is cooking stories, dating back to 2010, then the client should have the cognizance that attorney is there to facilitate the process. So, having said that, I believe, and what I'm seeing right now, the stakeholder, which is the Indian government, and I repeat, the Indian government, and especially all the offices. The best thing of intellectual property rights, at least in India, is everything is online. So you can see the dates, you can see, if something mischievous is happening, it will happen once. The coincidence happened once. The coincidence might happen twice. But if it is being repeated regularly on a regular interval, then, one has to take the cognizance that a situation might be that the data is being leaked from the Indian Patent Office or the Copyright Office, for that matter. Why I say so? When we talk about trade secrets, I have given this strategic advice to many clients, and even I have done it, for that matter. You file a provisional application before the Indian Patent Office, and you don't file a complete. So the Indian Patent Office database stores that data. Since it is not in public domain, it's a trade secret. And at any point of time that is leaked, it means there is leakage in the internal system of the Indian Patent Office. And it's very disturbing. Why I say so? I had 2 Madrid Protocol cases for hearing, and till morning 10:30 I didn't even receive a mail that who is the person in charge to talk about it or to see my case. Just to be on the safer side, irrespective of few emails coming from the government office which was dated back, not on the same date but a backdated email is coming to me stating that the hearing will not take place, it will happen in near future. Again, the point is the law says irrespective of the fact you have the hearing or not, you can submit your reply statement. And I'm of the opinion, irrespective what these organizations, whether it's the government stakeholder, whether it's a private stakeholder, I abide by the timelines and I have filed the reply statement irrespective of the fact I sit for the hearing or not, or I do the hearing or not. The examiner, whether it's trademark, whether it's patenting, in trademark we called as registrar, in patent we call people, the patent examiners. It's very disturbing to see what is happening right now in the Indian landscape. And another case which has happened, which is so funny, I haven't gone through the document properly, probably I'll upload that document. A patent examiner is saying that if you file something in the provisional, right, and now you file something in the complete application data will not be taken on record. So I think the sensitization has to be done properly for the patent examiners also. And I have been part of this Rajiv Gandhi Institute in Nagpur, and where I trained people to understand intellectual property rights, which was in association with World Intellectual Property Organization. And I think, sir, this is very appalling to see that this is the way the patent office is working, the copyright office is working. Why the data is being leaked from these organizations is the question stakeholder needs to answer. And this is for Mahalakshmi. You should question the government of India rather than questioning the attorney and stating the attorney that the attorney might have leaked the data to the third party. If all the data points are filed for the copyright, you need to make the Indian government, the Indian Copyright Office party to the case, not the lawyer, because the lawyer work is just to facilitate. Hope it serves your purpose, and if honestly the US company has taken your data points, I'm happy to facilitate it. But you have to give that I would say take cognizance of the fact that the attorney is there to help you out, rather than blaming the attorney that why the copyright was filed. Copyright was filed because that was not patentable, so whatever is left, it is filed in the copyright. There's nothing wrong in that. It's a strategy. I hope this solves your some pain points, and since the case is already ongoing in US, make both the Indian Patent Office and the Copyright Office party to the case and see what happens. See who are the people who will give affidavits before the US courts. I hope this solves your purpose, and if you have any questions, do write me email or have a clarity call just to have some clarity over what is ongoing. If something has been stolen from you in terms of intellectual property rights, then hold accountable the government of India also, because government of India also the data can be leaked. For everything in this world, the chances are 50-50. So take cognizance of that. Make Indian Patent Office, make Copyright Office party to the case, and see what happens. Wishing you all the best. And if you have any questions, I'm always there to assist you. Thank you for watching out the video.